Maryland Fair Housing Practice Test. Question 1. Which concept should a closing agent apply to facts involving a change in a housing rule or service needed for a person with a disability to have equal use and enjoyment? Option A. Abstract of title. Option B. Lead minus based paint disclosure. Option C. Price fixing. Option D. Reasonable accommodation. The correct answer is option D. Reasonable accommodation. A housing provider may request limited information when the need is not obvious. The request concerns policy or procedure rather than a structural change. Approval is required unless the request creates an undue burden or fundamental alteration. Question 2. PREA is studying a rule concerning the federal law prohibiting housing discrimination based on race, color, religion, sex, national origin, familial status, and disability. Which term should be chosen? Option A. Fair Housing Act. Option B. Abstract of title. Option C. Constructive notice. Option D. CERCLA. The correct answer is option A. Fair Housing Act. The protections apply to covered sales, rentals, advertising, and related services. Limited statutory exemptions do not permit discriminatory advertising. Licensees must provide equal professional service and avoid steering or discriminatory statements. Question 3. When a warehouse transaction involves a fibrous material formerly used in insulation, fireproofing, and building products, which answer identifies the controlling concept? Option A. Reasonable accommodation. Option B. Asbestos. Option C. Price fixing. Option D. Steering. The correct answer is option B. Asbestos. Its presence does not automatically require removal if it is intact and safely managed. The material is most hazardous when disturbed fibers become airborne. Proper inspection and removal require qualified professionals.
Stressed about your FCLE? We can take FCLE for you remotely and undetected. We always guarantee a pass and payments only after results. To send us an email, scan the code or tap the link in the description and let's get it done.
Question 4. A practice question describes a naturally occurring radioactive gas that can accumulate in buildings. Which response is best? Option A. CERCLA. Option B. Title insurance. Option C. Radon. Option D. Abstract of title. The correct answer is option C. Radon. Long-term exposure can create serious health risk. Mitigation systems can reduce levels when elevated readings are found. The gas is colorless and odorless, so testing is necessary to determine concentration. Question 5. During a lease negotiation, which principle is illustrated by the Maryland professional duty concerning significant property information? Option A. Avoid prizes, lotteries, or contests used to influence a property sale. Option B. Do not guarantee future resale profits. Option C. A penalty of up to $5,000 per violation. Option D. Disclose known or reasonably knowable material facts. The correct answer is option D. Disclose known or reasonably knowable material facts. Technical matters should be referred to qualified specialists when needed. The licensee should make a reasonable effort to ascertain material facts about property accepted for agency. Intentional concealment and negligent failure to investigate obvious issues can both support discipline. Question 6. Which answer states the concept associated with the Maryland duty when a licensee offers a contractor's name to a client? Option A. Verify a recommended home-improvement contractor's license annually. Option B. Disclose known or reasonably knowable material facts. Option C. Avoid prizes, lotteries, or contests used to influence a property sale. Option D. A penalty of up to $5,000 per violation. The correct answer is option A. Verify a recommended home-improvement contractor's license annually. The licensee checks the contractor's status through the Home Improvement Commission each year before making the referral. The client must be told where the licensing information is available and the date of verification. The statute treats this referral differently from several other listed service providers. Question 7. A listing broker handling an office building in Columbia must identify a Maryland disciplinary restriction on specified promotional methods. Which choice is correct? Option A. Do not guarantee future resale profits. Option B. Avoid prizes, lotteries, or contests used to influence a property sale. Option C. A penalty of up to $5,000 per violation. Option D. Disclose known or reasonably knowable material facts. The correct answer is option B. Avoid prizes, lotteries, or contests used to influence a property sale. Advertising a free appraisal is also restricted unless it is genuinely available without regard to the requester's purpose. The rule prevents promotional devices from improperly inducing consumers in a real estate transaction. Marketing programs must be reviewed before launch for licensing and consumer-protection compliance. Question 8. During a due-diligence meeting for a waterfront parcel in Towson, Amina needs to identify the rule described as direct knowledge of a fact or claim affecting property. Which answer applies? Option A, special warranty deed. Option B, CERCLA. Option C, actual notice. Option D, reasonable accommodation. The correct answer is option C, actual notice. The information may come from documents, statements, observation, or personal awareness. Both direct and record-based notice can affect purchaser rights. A person with direct knowledge cannot rely on failure to record as though the issue were unknown.
Are you looking for FCLE actual questions? Visit our website pokerexams.com to access FCLE study guide with actual questions and answers. Scan the QR code or click the link in the description to get FCLE answer key today.
Question 9. A associate broker is reviewing a retail suite in Gaithersburg. Which term describes a court proceeding used to resolve competing claims and establish ownership rights? Option A, general warranty deed. Option B, abstract of title. Option C, underground storage tank. Option D, quiet title action. The correct answer is option D, quiet title action. The procedure is different from title insurance, which shifts covered financial risk. The judgment can remove invalid claims and clarify the state of title. Interested parties must receive proper notice and an opportunity to be heard. Question 10. At a property-management audit, a Maryland exam candidate encounters the following description: coordinated refusal by competitors to deal with a person or business. Which concept is being tested? Option A, group boycott. Option B, underground storage tank. Option C, antitrust law. Option D, reasonable modification. The correct answer is option A, group boycott. Brokerages must make independent decisions about vendors and cooperation. Collective punishment for discounting or innovation creates substantial antitrust exposure. The conduct can unlawfully pressure the target and restrict market access. Question 11. Rena is assisting with a mixed-use property transaction in Rockville. Which principle applies when the facts involve a physical change to housing needed by a person with a disability? Option A, price fixing. Option B, reasonable modification. Option C, special warranty deed. Option D, actual notice. The correct answer is option B, reasonable modification. The request should be evaluated individually rather than rejected by a blanket rule. Responsibility for cost and restoration depends on the housing type and applicable law. The resident may be permitted to install accessibility features subject to lawful conditions. Question 12. Which answer most accurately identifies an agreement among competitors to establish or stabilize prices or commission terms in a real estate transaction? Option A, steering. Option B, title insurance. Option C, price fixing. Option D, market allocation. The correct answer is option C, price fixing. Each brokerage must make independent pricing decisions. The agreement can be unlawful even when the chosen rate appears reasonable. Informal conversations or coordinated minimum fees can create serious risk. Question 13. A question arising during contract revision concerns communication of a known condition that significantly affects value, desirability, or safety. Which choice gives the best classification? Option A, CERCLA. Option B, reasonable accommodation. Option C, group boycott. Option D, material defect disclosure. The correct answer is option D, material defect disclosure. The duty can apply even when a seller prefers silence. A licensee should not conceal a serious problem or make misleading assurances. Experts should evaluate technical conditions outside the licensee's competence. Question 14. While analyzing a rental home, CARA must apply the concept involving federal and state rules protecting competition from agreements that restrain trade. Which answer should be selected? Option A, antitrust law. Option B, Americans with Disabilities Act. Option C, cloud on title. Option D, market allocation. The correct answer is option A, antitrust law. Brokerages must independently set commission rates, fees, and business policies. Industry custom is not a defense to coordinated conduct. Competitors cannot agree to divide markets, boycott firms, or fix prices. Question 15. Which real estate term is defined by insurance protecting against covered title defects that existed before the policy date? Option A, underground storage tank. Option B, title insurance. Option C, Megan's Law notice. Option D, cloud on title. The correct answer is option B, title insurance. The policy does not guarantee the property's physical condition or future market value. An owner policy protects the buyer's interest, while a lender policy protects the mortgagee. Coverage depends on policy terms, exclusions, and exceptions shown in the commitment. Question 16. In a transaction involving a cooperative unit, which rule controls when there is an investigation used to identify potential environmental contamination or recognized conditions? Option A, blockbusting. Option B, material defect disclosure. Option C, environmental site assessment. Option D, group boycott. The correct answer is option C, environmental site assessment. A standard initial assessment does not necessarily include sampling or guarantee that no contamination exists. Commercial purchasers and lenders use the process for risk management and due diligence. The scope can include records review, site inspection, and interviews. Question 17. A landlord asks about a notice directing consumers to official sources for registered offender information rather than making the licensee the investigator. Which answer provides the legally accurate concept? Option A, asbestos. Option B, Fair Housing Act. Option C, special warranty deed. Option D, Megan's Law notice. The correct answer is option D, Megan's Law notice. The issue should be handled consistently and without discriminatory assumptions. Consumers can consult the designated government registry for current data. Licensees should provide the required notice and avoid unsupported representations about individuals or neighborhoods. Question 18. Quinton encounters directing housing consumers toward or away from areas based on protected characteristics during a per-listing meeting. Which principle should guide the analysis? Option A, steering. Option B, underground storage tank. Option C, market allocation. Option D, redlining. The correct answer is option A, steering. The practice restricts consumer choice and perpetuates segregation. Comments about neighborhood composition or where a family would fit can create violations. Licensees should provide objective property and community information based on the client's stated criteria.
Stressed about your FCLE? We can take FCLE for you remotely and undetected. We always guarantee a pass and payments only after results. To send us an email, scan the code or tap the link in the description and let's get it done.
Question 19. Which choice best matches the description conditioning the purchase of one service on the buyer also obtaining a separate service? Option A, group boycott. Option B, time-in arrangement. Option C, CERCLA. Option D, Megan's Law notice. The correct answer is option B, time-in arrangement. Required use of an affiliated service should be reviewed under settlement-service and antitrust rules. The practice can restrict consumer choice and competition when market power and other legal elements are present. Voluntary bundled offerings must be disclosed accurately. Question 20. During review of a vacant parcel in College Park, the parties discuss the federal law requiring accessibility and non-discrimination in covered public accommodations and commercial facilities. Which term applies? Option A, radon. Option B, Megan's Law notice. Option C, Americans with Disabilities Act. Option D, recording. The correct answer is option C, Americans with Disabilities Act. Brokerage offices open to the public may need reasonable access and communication accommodations. Building age and scope of alteration affect technical accessibility requirements. The law is separate from housing-specific reasonable accommodation and modification duties. Question 21. An exam scenario presents the maximum administrative monetary penalty Maryland may impose under the cited disciplinary section. Which answer is most accurate in the inspection period described? Option A, disclose known or reasonably knowable material facts. Option B, avoid prizes, lotteries, or contests used to influence a property sale. Option C, do not guarantee future resale profits. Option D, a penalty of up to $5,000 per violation. The correct answer is option D, a penalty of up to $5,000 per violation. Separate violations can create separate penalty exposure. The Commission considers seriousness, harm, good faith, and prior violations when setting an amount. The fine may be imposed instead of or in addition to reprimand, suspension, or revocation. Question 22. A licensee preparing for a property management audit must recognize a Maryland disciplinary rule addressing misleading investment promises. Which concept does this describe? Option A. Do not guarantee future resale profits. Option B. Verify a recommended home improvement contractor's license annually. Option C. A penalty of up to $5,000 per violation. Option D. Avoid prizes, lotteries, or contests used to influence a property sale. The correct answer is option A. Do not guarantee future resale profits. Market conditions are uncertain and such claims can deceptively influence a purchase. Investment analysis must use reasonable assumptions and clear limitations. A licensee cannot assure a buyer that later resale will produce a profit. Question 23. Which answer correctly classifies a situation involving the federal law establishing liability and cleanup authority for releases of hazardous substances? Option A. Title insurance. Option B. CERCLA. Option C. Group boycott. Option D. General warranty deed. The correct answer is option B. CERCLA. Environmental due diligence may support statutory defenses for qualifying purchasers. Liability can extend beyond the person who originally caused the contamination. Potentially responsible parties can face substantial cleanup obligations. Question 24. At a settlement preparation in Ocean City, Caleb explains a buried container that can create soil and groundwater contamination risk if it leaks. Which real estate principle is involved? Option A. Time-an arrangement. Option B. Title insurance. Option C. Underground storage tank. Option D. Environmental site assessment. The correct answer is option C. Underground storage tank. Former heating-oil or fuel tanks may require investigation and regulatory compliance. Visual inspection alone may not reveal the tank or contamination. Environmental professionals should evaluate suspected conditions. Question 25. A transaction file for a historic residence raises an issue involving inducing owners to sell by suggesting protected groups are moving into the area and property values will decline. Which answer best resolves the classification? Option A. Radon. Option B. Fair Housing Act. Option C. Reasonable accommodation. Option D. Blockbusting. The correct answer is option D. Blockbusting. It is prohibited even if the licensee claims the statement reflects market opinion. The conduct exploits fear and discriminatory assumptions for transaction activity. Marketing should never use protected class change as a reason to buy or sell.